All right, Bill Henry here, attorney with Robinson Henry, back for another estate planning Thursday, where I answer questions live and talk about other things related to estate planning and elder law. And that's where I'd like to start today. So as I prepare for this, just generally throughout the week, I'm on Google doing various things. One thing I happen to come across were a number of searches that people were making, and they want to know how they can hide assets Medicaid. And if you go down on Google, at the bottom, related party or related search, and other people want to know, how do I hide assets from the nursing home, do other untoward things like that. So I'm going to address that quickly. Terrible idea. Do not recommend hiding assets from Medicaid. And what people really mean by that is not disclosing assets. And so I wanted to quickly go over the law as it concerns hiding our assets. So the first thing is, it is a crime, as you probably imagine. Under Colorado law, it is under the Colorado Medicaid False Claims Act, and then federally there is another False Claims Act. So what happens if you do that? Well, if you do not disclose your assets on the Medicaid application, and you intentionally do that, or you help somebody do that, well, you'd be in for some jail time because you did that. And you could also, of course, be fined, and you could be liable for attorney's fees for recovering that money against you. So I think it's pretty clear that we shouldn't hide our money. Also should point out federally, like I mentioned, it can be crime there as well. And there, under the federal law, you can be liable for 3 times the amount as well that you damage the government. So lots of ways you can go to jail for it. Don't do it. What do we do though instead? So let's take a situation we've talked about similar in the past, where I've got $50,000, or let's be easier, I got $10,000. I qualify for Medicaid. I know I'm going to need that in paying for the nursing home. What do I do? How do I get around the issue where I'm over-resourced or too much money? You can legally transfer your assets to a different type, if you will. In other words, if I've got $10,000 and I go buy a car, well, in most cases, Medicaid is not going to count that against you or not count that against your loved one. And you can fully disclose that. Not only should you or can you, but you should fully disclose that to Medicaid. You can say, hey, I had $10,000. I went out to buy a car. Cars are exempt under the law. And that's not an issue. So my message to you is hide nothing, disclose everything, and at the same time, just know all the laws, or find an attorney, give us a call on the Medicaid laws, so that way you can be kept up to speed, and you can plan for a Medicaid filing and make the most out of it. All right, so let's talk about a few different questions that we get from time to time, and then of course if anything comes in live, we'll answer those as well. So one question here is, how are timeshare handled in the estate plan? I can tell you I personally about this, because my grandfather gifted me a timeshare. Well, what do we do? I don't want the timeshare. It's in Florida. I live in Colorado. I'm never going to go there. So the question is, do I become liable? He had the exact same name as me, so the company, on top of everything else, was sending all of his bills. And so the question is, am I liable for my grandfather's timeshare because he did that to me? And he said, no, you're not. So unless I went ahead, signed on the dotted line with the timeshare company, and I said, all right, I agree that I will become legally responsible for the debt on this, well, then I'm not liable. So does that mean I just don't have to pay the monthly HOA dues? And that's really the big issue with timeshares. No, I don't have to pay it, but if I don't pay it, what's going to happen, of course, is the company is going to foreclose on that. So even though it's just a week or a fractional ownership at this resort, they can still foreclose. It is still an interest in real estate. So the message is that if you inherit a timeshare, then you don't have to accept it. 1, 2, you don't have to become liable for it, and you don't have to pay that. If you're the one with the timeshare and you can't figure out how to get rid of it, well, normally it's bankruptcy or death. There are some companies out there, but I think you're going to find that it's pretty hard to get rid of a timeshare. And having said that, there's timeshares up here in Colorado, of course, that are worth it. If you've got 2 weeks up at Beaver Creek over Christmas and New Year, all that's got some value to it, and you probably can sell it. Different things for different timeshares, kind of depends on the value and what you want to do with it. But the message is, of course, you don't have to keep the timeshare as a beneficiary under a will. Next, how many contingency heirs should I have? I think what we're talking about there is how many backups. In other words, if I say give my property to my kids, should have people that are behind that. So in other words, should I then have a backup behind the kids? It really just depends on your own, what you personally want to do. So for example, if I say give it to my kids, and if they've predeceased to their children, that's something you'll hear called by representation. But needless to say, if it goes to your kids, in most cases, if your child had predeceased you, then it's going to go to their kids, your grandchildren. So do you need anyone behind it? Again, it's just completely a personal choice as to what you'd prefer. If you don't have anyone behind you, well, what's going to happen? Then we'd ultimately default to state law. So if there are no heirs for property, state law will take over. Well, what's state law going to do? It's very fact dependent on your circumstances. Let me give you at least a little bit of an idea of what that would look like. If you have parents that are alive and you have no descendants, then it can go to your parents. If your spouse, a lot depends on if your spouse has stepchildren. Excuse me, if you have stepchildren, your spouse has their own biological children, but they're stepchildren, or vice versa. If you have your own children, then and they're your spouse's stepchildren, then the law may call for that inheritance split between your spouse and your children. Ultimately, if you've got no parents or children or spouse, you can go to your brothers and sisters. Theoretically, can ultimately to the state. I know that's a concern that a lot of people have. Like, hey, I don't want all my property to go to the state ever under any circumstance. First, unlikely that that's going to happen. Most often, we can find error, but if you really want to know that result, you can always have what's called a catch-all and says, hey, if no error can be found, and I want it to go to a charity, and you can pick a big national charity. You could have your personal representative, that's the executor under the will, say if you can't find this big, huge charity, if they've gone out of business, then hey, personal representative, you can go ahead and pick another charity. So you got lots of options there. I would really say, though, the number of heirs you should have depends on your personal circumstances. If you have children and grandchildren, that may be enough. And a spouse that's alive, you're talking about a lot of different possibilities. So if you have a spouse and then your entire family tree consists of 10 more people, it's unlikely that you're going to need someone behind that. So good question. I'll answer that without a lot of specifics on that. Let's talk about reverse mortgages and estate planning. I deal with these time to time, particularly in the elder law context. This way that we can pay for our nursing home care costs using a reverse mortgage. Some people want to, some people don't. But the question is, well, if I do have a reverse mortgage, what happened to my estate plan? How is this going to be handled? There's a lot of misinformation out there. I'm not, of course, an expert in reverse mortgages. You need to go to a reverse mortgage broker for that. But basically, at the end of the day, nowadays, a reverse mortgage is simply a loan. It's just a loan that doesn't have paid until the person normally either sells the house or dies. One of those two. Then, however much money they took, plus the interest, is going to go and be repaid back to the reverse mortgage company. Everything else, in terms of all the other equity, is just going to be your heirs, however you want to handle it in your state. So just to give you a quick example, if I have a house and it's worth $300,000, I go out and get a reverse mortgage, and upon my death, I have loan balance because I was withdrawing money from the house, $100,000. Well, then the reverse mortgage company, upon your death, is going to get $100,000. That other $200,000 is going to go to yours. So again, it can really be handled just about any way you can imagine in your estate plan. Now, having said, transfers to irrevocable trust, there's a lot of problems if you have a reverse mortgage, particularly if you have some sort of a Medicaid protection trust or some other irrevocable trust. You really want to be careful with making those transfers. You can cause some big issues in your reverse mortgage. You can trigger the sale. I mean, a lot of other things. Careful when you do that. Make sure you're using competent counsel and competent representation to handle those issues. All right, let's see what else we have here on my list. Let's talk about joint wills a little. So what is a joint will? A joint will can mean a lot to a lot of different people, but one way to think about it is a will that two people make simultaneously. And the idea behind it is created this will, And it says that the survivor of the two of us gets everything, but the person that died can rest assured that their property will go to heirs that are listed in the will. I can tell you as an attorney, I've been doing this a long time, I have done a lot of wills. I have never done a joint will, so I really don't recommend them for a lot of reasons. And I'll talk about a better approach would be, at least in my opinion. So the first thing is, a will is only going to transfer your probate assets. Well, what are those? Those are the assets that are passed under the will. Well, that still doesn't make any sense. So what's that mean? Let's take an example. Let's say I have a 401k, and in my 401k, I list a beneficiary and I say, give my $100,000 of my 401k to my brother Rob. Then I say, give all money, all assets to my kids. Who is going to get the money for 401ks of my brother? Is listed as an beneficiary first, or alternatively, is it my sort of list? Well, what's back to this issue of pro, not pro? That's if it's that's a probate asset. Unfortunately, 401 because the brother lists me, he's getting money, not my kids. So point being, will only or probate assets. In most states, we have probate and non-probate assets, so it doesn't do anything we want to do. So would be a better solution in using what well. Instead, we would turn it's a transfer really classic example for us to do a lot when we've got families, there's a lot of kids out, and basically what the concern that spouses has on to take from my spouse for the rest of her life. But on there, going to make sure function of my ass goes to my biological children from a pre-marriage or pre-relationship. And it's the classic use of this right that we create us to become revocable on death. That moves into this whatever for the also income for the spouse access for their surviving us for their health education and so wherever rules we want to have. Whenever that survivor dies, that survive out, then money is going to go to mother children, example. So that would I would go. Just really don't recommend them. I've never done, but you could find it that would if you are interested. Let's see here. Tenancy. So I talk a lot about joint tenancy. I talk about it in almost every workshop that I do. There's nothing wrong with joint tenancy. It's a great way to avoid probate upon death. You normally would see it between spouses. So husband and wife put their name on title to the house, and they say, upon my death, then to the survivor gets the property automatically, 100%. No problem there. They get avoided back. They see the problem in as we start putting kids and loved ones on our house. They could have a lot of issues. First and foremost, our kids, their property become worse because they actually own a house or a portion of ours. So they put a lien in their house. There's consent liquid their share house. A lot of things can happen. And the tax consequences too is if I my property over to somebody, get what's like carry a basis. And what simply means whatever I afford, so it's like for they go to the house, they have to tax for me. So, quick example there: if I bought a house for $100,000, and whenever I gifted it to them, it was worth $500,000, and then say they sell it immediately the next day, well, they're going to pay tax on their share of that property. So that would be $50,000, right, for the amount, their share of what I bought it for, 100,000 divided by 2. And then their share of the gain would be $200,000. So they're going to pay $150,000, or excuse me, their income on the house would be $150,000, and they'll pay tax on that. Alternatively, if I give it to them upon my death, well, now all of a sudden I got a completely different result in that they get what's called a step up in basis. And it's as if they bought the property for the value on the death, for example. They probably wouldn't pay any tax at all. Both spouse not necessarily deal. Some who don't want to add for state tax purposes, but for the part right now, an $11.5 million tax hit. We're super concerned with it. Those people, but again, be careful when you're in your house, your boy's girlfriend. We those issues all the time, and I came from our relation to the firm. Those cases can get very extensive on how those are handled. All right, let's see here. Here's a great one. This one comes up all the time. I have a medical power of attorney for my mom. recently entered to a long-term care nursing. She has dementia, but what I do not have is a financial return. So how do I make financial decisions for her? So there's a lot, of course, in there. We've talked about the fact that first, somebody that has dementia can potentially sign estate planning documents. It just depends on their level of testamentary capacity or whether or not they know what they're signing. Do they know who their agents are? So that's kind of our first question. We really don't know the answer to that. To back it up a bit, though, in this question, we've got a medical power of attorney. So that means that the person can make medical decisions for their mother. But they don't have a financial power of attorney, so they can't financial decisions. They can't bills and write out of checking accounts. A medical power of attorney is not the same as a financial power of attorney. For all the legal beagles out there in Colorado, we call a financial power of attorney a general power of attorney. Regardless, it deals with finances. So what do we do in this case? Well, first, back to what I was saying, if mom has capacity, she can go ahead and sign a financial power of attorney. How would you know capacity? Well, of course, talk to a lawyer, talk to doctors, things like that. If mom doesn't have capacity, we can assume, I guess, per point is block here that she has capacity. Well, what do we do in that case? We have to go to court, and we ask the court for what's called a conservatorship. The court will appoint someone over mom's estate. Of course, the daughter, I think it was a daughter, she's going to ask the court, say, hey, I want to be the conservator. I think it's best for mom. If nobody objects, most likely the court's going to do that. So conservatorship, if we don't have a financial power of attorney, conservatorships, it's a court action. It's going to be more expensive, way more intrusive. You got to do filings with the court every year. It's way better if you can get a financial power of attorney in place, and that really goes for all of us. We should all have medical powers of attorney and financial powers of attorney, like I've talked about a few times in the past. All right, so let's see here. We need pour over. The pour will is a way that attorneys morph to a will that said, take everything that goes through Bay, and I want you to give it to something. Normally it's a trust. So pour it all over into my trust. What's the idea behind it? If I have a trust, I create a living trust during my life. I take all my assets and I put them into this trust. So let's just say I got one asset to make this easy. I got my house. I take my house and I put it into the trust. Well, fast forward 2 years goes by and I happen to buy a vacation home in Florida. And I just forget about the whole trust thing and I don't put my vacation home into the trust. I don't transfer the title into the trust and then I die. Well, what happens? If our will isn't what we would refer to as a pour-over will, in other words, it doesn't say put everything I have into the trust, that house does not go into the trust. So just because we die with trust doesn't mean our assets on the land not go in there. Instead, with these things called pour-over will, we simply say pour over all my assets, like this place, vacation home in Florida, and it into the trust if I missed it. That's why we're going to use a pour-over will. So really, really good question there. Confusing. I agree. Like we have all these different types of wills. I think it's just a good point that when we talk about trust and we talk about wills, there's just a wide variety of wills and trusts, right? I can have irrevocable trust, testamentary trust, living trust. A trust is just the term for what we write down in this contract. Same thing for a will. There's lots of different ways that we can set up wills. We can have wills with trust. We can have wills without trust. We can have pour-over wills, joint wills, contractual wills. And it goes on because the will is just a catch-all name. There is no such thing as just one type of will. It's really about what we are trying to achieve and how we write the documents. Let's see if we got anything else that came in. Looks like my sound is weird, hard to understand me. I apologize for that, and I'd be frozen. So I think we're going to have to cut there. I apologize for that, and if I have to, I will read all these questions next time. And we'll leave it there.